Hello, everyone, and welcome to our webinar on the IP implications of generative AI in Europe. My name is Adam Rendell, and I'm a partner in the London office of Taylor Wessing, specialising in copyright, advertising and media law. And I and the team have been advising on issues we're going to be talking about since long before ChatGPT became a thing last year. Taylor Wessing represents the world's most innovative companies and people. We've got a long history of being a top-rated firm for IP and technology across our international footprint. So I'm delighted to be chairing this webinar and to be joined by a stellar lineup of our IP specialist colleagues. We have Zuyang Zhu, a senior counsel in our London office, Gregor Schmid, a partner in our Berlin office, Mark Schuler, a partner in our Paris office, and joining us from our strategic alliance firm in Spain, we have Cristina Villasante, a partner at Erija. It feels like not a day goes by without AI being part of the conversation. So what we wanted to do today was discuss our European perspectives on 6 questions that keep coming up for us. They're on the slide now. Please feel free to post your questions in the questions box, which should be on the bottom right of your screen. We'll do our best to pick them up as we go along, but anything we don't manage to pick up during the session, we can follow up with you afterwards. Before we start on the 6 questions, a quick reminder of what generative AI is. We're dealing here with AI systems whose purpose is to generate outputs, which if a human author had created them, we would be thinking of them as copyright works. At a high level, how this works, sophisticated generative AI models are trained on massive data sets, text, images, music, or software. And they learn to recognize highly nuanced patterns and relationships within that training data. The training process analyzes characteristics of the data to identify, for example, what makes a cat look like a cat and not like a dog, what makes a piece of pop music rather than a piece of classical music. When that training happens, in theory, the model shouldn't memorize the data itself, whether that's strings of text or images, but only relational principles that are present in the data. But in practice, we've probably all seen examples which suggest that the effect, if not the reality, is that specific content has been memorized. Then a user gets hold of the model and puts in a text prompt. When responding to the prompt, the generative AI system will use interpolation to generate a response based on its learned relationship principles. If the user asks the model to generate a picture of a cat in a hat, it will use those principles to generate the image. But the image wouldn't be based on a particular image of a cat, but on what it has learned about what makes a cat, or what makes a hat, a hat. This is what makes generative AI different to machine learning. Not only is the system identifying and classifying images as cats, it can then generate an image of a cat based on the prompt. Now, again, in theory, the output should be a wholly new output generated from scratch. But in practice, it can, in some instances, be similar or identical to material present in the data. Now, where on that spectrum between theory and practice a particular model falls is probably the most important thing for us lawyers to get to grips with when advising on the risks of generative AI. And we'll see the impact that has as we go through these 6 questions we're going to discuss today. So, with no further ado, in light of that background, question 1: is it possible for AI models to be trained on data sets without infringing IP rights in those data sets?
Yeah. So thank you, Alan. Yeah. So I think that as you were saying, when we are talking about AI, we are talking about extraction of massive and available data on the internet. So if we are doing this extraction with some techniques or process as text and data mining, we have to think about that this is going to involve reproduction and storing of full data. So that means that we are doing maybe acts of exploitation of rights. So we will need from the beginning the license from the right holders. If we don't have the authorization of the right holders, maybe we cannot do this process of text and data mining in order to train our AI system. So this is something that we have to consider. But there is another thing, and the thing is that the copyright regulation in each jurisdiction has been or has a statute or comply with some exception, that is this text and data mining exception. So maybe what we have to think about is that if we are in a jurisdiction where this exception is allowed, and then we don't need authorization from the copyrights holders in order to do this process, because there is a law that is except from the copyrights to do this process. Okay. The thing is that, of course, we need to see or to analyze which are the requirements of this exception that the jurisdiction where we are states. So, for example, there are differences between some jurisdiction. Maybe Suyan can tell us later what about UK. But if we think about European Union, since 2019, European Union allows web scraping through text and data mining techniques for those who have legitimate access to the work. This is very important. But there is, however, this exception, the right holders can have the option to exclude their works from the text and data mining exception. So with some mechanisms, as for example, robots or disclaimers in their websites. Okay, so this is something that is not so easy, and we have to analyze if we comply with all requirements in order to be under such exception and to not need to authorize or to have the authorization of the right holders in order to do this process of text and data mining. Okay, so another thing that we can think about is which kind of act of exploitation of rights are involving in that process, because we can think about, for example, reproduction, the act of reproduction of the works. If we need to load the work in a data mining platform in order to do this text and data mining process, or to convert an image into text to do this data mining process, then we are involving the act of reproduction. But we could also think if this reproduction act is something that is necessary, is temporary, and maybe then it can be under a limitation of copyrights that is under the regulation of the European Union. But the thing is that I think the conclusion of this is that we cannot be under that limitation of temporary reproduction, because we are not facilitating any network transmission in that act of reproduction, and there is something very important here when we are talking about generative AI, and is that we are going to also not only to reproduce the work, but also to transform the work. So there are two acts of exploitation, not only reproduction, but also the transformation of work. So we finally cannot be under that limitation. There's another thing to consider, and is that there is independent economic significance on that act. And another important thing is that such copies that we are going to use are not automatically erased. So at the end, they are not temporary reproduction, because AI needs to use that reproduction again and again in order to be trained. Another act that is going to be involved in that AI systems are the communication, the public communication. When we use the works that we are using for the training and for this in this text and data mining process, in the result of the produce. If the works are in the results, even if such works are in a reduced are reduced and are not exactly the same work as the one that was used in order to train the AI system, then we will be public communication will be involved in that. in that act or process. So at the end of the day, we have to analyze if we have the authorization of the rights, we are under an exception of text and data mining with all the considerations that we have seen. Something that is under a debate also is that when AI is extracting information from the works to train the AI system, this information that is using is only the ideas of the works in order to train and to create new other works. So the thing is that if the ideas, because we have to think about that an idea is not protectable under intellectual property law. So if an idea is not protectable under intellectual property law, are we infringement any or involving any copyright or intellectual property right? We only are using the idea and information beyond or behind a work in order to train our AI system. Well, this is something that is under the debate, as I say, so we will need to see case by case basis what is going on in that copyrights or in that process of training in order to see if we are infringement or not right holders copyright. And of course, we have to also to pay attention on the European AI Act that later we are going to talk about.
But what I would add to that is that in relation to the text and data mining exception, what we can see that the local implementation and the construction of the text of this exception show that the exception as such raises some issue and debate. I just said the right to oppose may result from a machine-readable mechanism or disclaimers on website, as Christina highlighted a few minutes ago. Well, typically when you look at French laws, the opt-out mechanism as such is organized for authors of the work only. If we take the example of comics, authors may express their opposition, but publishers, distributors, and other intermediaries involved in the sale of the comics, and which may display part or whole of the comics concerned on their website, may not have the capacity to actually oppose, except if they do it in the name and on behalf of the authors. In many cases, they do not have any contractual relationship with the authors, and in this context, the effective implementation of the right to oppose it may show some complexity. On another topic, opposing through general terms of a website further raise some question as to whether or not these terms are per se enforceable in the absence of any form of acceptance. Typically in other matters, judges have considered that the mere visit of a website does not necessarily mean that any terms of the general terms are actually binding upon such visitors. These hesitations around the practical efficiency of the right to oppose lead to strong opposition against the application of the text and data mining exception in the context of AI system. As any other exception, we need to remember that the text and data mining exception shall pass the triple test. That is to say, it should be confined to certain special cases which do not conflict with the normal exploitation of the work and do not unreasonably prejudice the legitimate interest of the right holder. When the text and data mining exception was enacted, I mean, for sure, its application to AI system was not necessarily fully anticipated. And when we think about today's impact of AI system in illustration and graphic text sectors, we can clearly not exclude that local judges may adopt a strict approach of the triple test, and the exception may not be automatically applied for machine learning. This will be something to be really discussed at the local level and at the court level.
It's interesting to hear some of the issues that arise with the text and data mining exception as it's been enacted in various EU member states. Speaking from the UK point of view, we don't have a general text and data mining exception that applies to training AI models for commercial purposes. We only have a non-commercial exception, and broadening out into a more general purpose TDM exception has been something that's sort of been on and off the table and still somewhat up in the air. The government last summer proposed that it would expand into a more general text and data mining exception that would be subject to a similar kind of lawful access requirement as you have in the EU. February this year, it decided not to do that in response to sort of negative industry reaction, but we still have policymakers who are talking about this and recommending that we do this. So it's definitely, it hasn't gone away. It's still a point of quite intense lobbying. So some of the lessons learned from the European experience will be sort of a useful thing to feed into that. And while that's going on, what we do have in the UK, which Christina also mentioned, is the temporary copying exception. This is really kind of the main thing that AI companies training models for commercial purposes can rely on. It's very fact specific. So, I mean, Christina, you mentioned the copies need to be truly temporary. They need to be transient and incidental. They need to be an integral and essential part of a technological process, the sole purpose of which is to enable a lawful use of the work, and the copies need to have no independent economic significance. And when we've advised on this, we've had to get very, very much in the detail of exactly how the training's taking place, what the copies are, how long they're kept, what exactly the tool is producing, how it operates. And it's, you know, it's not a super straightforward analysis, but it's sort of what we have right now. And the other thing that we have on the cards in terms of availability of training data is the UK Intellectual Property Office is putting together a code of conduct this summer, which essentially is intended to create a sort of reasonable licensing scheme where rights holders sign up and they contribute works. AI companies can use those for training, but subject to sort of reasonable licensing terms and safeguards. How useful that'll be depends really on which rights holders join up and whether works are actually available at scale.
Picking up what you made, Ziyang, on the temporary copies exception and how when we were advising on it, we have to kind of get into the detail of exactly how the training works. My next question then becomes, what elements of the training process can increase the infringement risk, or conversely, can make it less likely that the exceptions that you've been discussing would apply?
Well, actually, we've just discussed some condition attached to the text and data mining exception, but one should remember that on top of the conditions we've just discussed, the exception requires, one, the destruction of the data after the machine learning has been performed, and two, the demonstration that proper security measures have been taken during the machine learning process. Typically, under French laws, any producer of an AI system must provide such information on request of the right holders. In this context, the risk of infringement will be increased if some training data remains stored under any form after the machine learning process in the AI system. Furthermore, the longer the process takes, the highest will be the standard in terms of data security. The technical state of art on this front may be highly debated, taking into account the possible impact on the application of the exception as such.
Just on the sort of UK temporary copying side of this, obviously a key factor is the duration of storage of any copies. So in the typical case where someone's training an AI model, the training process as a whole can take a number of months. The model has to pass over the training works a number of times. If someone's trying to rely on the temporary copying exception to store works for that whole period of many months, that's likely to be much less straightforward than if they already have the works. For example, they've been licensed in for some other reason, and then the only copies that are made that are associated with the training are, for example, copies made in the model's cache as it's passing over the works and reading them, those sorts of copies are more likely to fall under the exception. But of course, as well as duration, an AI provider would also need to meet the lawful purpose and the no independent economic value tests.
Yeah, maybe I would like another aspect. As Christina has mentioned, TDM is often made, or is generally made, on the basis of material, of huge amounts of material available online on the basis of web scraping, and which we've looked at under copyright law. In these circumstances, however, further risks potentially may arise if the scraping is considered as unfair competition under local law, which may again give rise to claims for cease and desist and possible damages. This can, by the way, apply to both copyright protected works as well as to databases. As you may know, under European case law, it's clear that the scraping of databases available online may infringe the sui generis database right of the database owner if those acts adversely affect the possibility to recoup the investment. For example, if a competing product is created. Of course, the database right is now also subject to the text and data mining exception, which you've just discussed. However, there's case law, for example, by the German Federal Supreme Court, which stated that if a website is scraped and for that purpose, a measure which was designed to technically protect the content, which may or may not be the same as the requirement under the TDM exception of the lawfully accessible content, if such a technical protection measure was circumvented, this may amount to an act of unfair competition. So there may be an increased risk of unfair competition law infringement. But to what extent that still applies and how that goes along with the TDM exception will be probably subject to case law.
So we've been hearing there about the sort of jurisdiction-specific copyright exceptions, database right exceptions in the UK and across the EU. But we know there are countries around the world that have got more permissive TDM regimes, maybe more permissive machine learning, and have few of the conditions that we've just been discussing that need to comply with, whether that's lawful access, whether that's the temporary nature of the reproduction. So if the hypothetical machine learning process and all the training data are stored in one of those more permissive regimes, is it possible to sort of offshore your training in one of those regimes and then kind of reappear back into the UK or the EU with this perfectly formed training model, and then also trained model, and then carry out the generation of the outputs in the UK or EU?
Yeah, I'm happy to pick up on that, and I'd like to address this question really from a copyright perspective, but also from the perspective of the draft AI Act of the European Union. So as regards copyright, the kind of general rule is that copyright law is territorial, which means that the law of the country applies for which protection is claimed. So assuming a situation where the text and data mining is exclusively done in a more permissive jurisdictions and the training as well, outside the EU, where the text and data mining and the training does not infringe, you could consider situations where the material is exclusively stored on servers outside of the EU. That would be, for that part, be a possible way to evade the stricter EU laws. And once the training is finished, the trained model could also be imported into the EU. So that could be a way out. Of course, it has to be considered whether the output then, using the trained model, which you mentioned before, Adam, could infringe copyright on the later stage. As regards the AI Act, it gets a little bit more difficult. The current draft of the AI Act, as you may be aware, was proposed by the European Parliament on 14th of June, includes new provisions on copyright. They are not really, in the real sense, copyright law, but they relate to copyright. Briefly speaking, they require that the developer of a generative AI model develops the model in such a way as to ensure adequate safeguards against the infringement of rights. And in addition, to make publicly available a sufficiently detailed summary of the use of training data which are protected under copyright law. So there are certain requirements under the AI Act as it currently is proposed. The Draft AI Act now has far wider application than copyright law. Similar to other European laws, it shall apply to providers that are either based in the EU or place their AI system on the market or put it into service in the EU. So whenever you want to offer an AI system in the EU, you would be caught by the AI Act. In addition, it would also be applicable if the output is intended to be used in the EU or if the importers or distributors of the system are located in the EU. So while the risk of copyright infringement could be reduced to a degree by training the model in a more permissive jurisdiction, it's still very likely that the AI Act will still apply.
Just to chime in on the copyright side of this, so Getty at the moment is suing Stability AI in the English High Court for infringement. Getty's alleging that Stability AI infringed copyright in Getty images in the course of training the Stable Diffusion model, that the outputs of the model infringe copyright and also trademark rights, which we'll come on to in another question later. But the claim also includes quite an interesting additional claim, namely that Stability AI is carrying out various acts that attract secondary infringement, namely importing Stable Diffusion into the UK, possessing it in the course of a business, selling or letting it for hire, or offering or exposing it for sale. And these claims are based on a contention that Stable Diffusion is in and of itself an infringing copy of some or any of the Getty works, which is a curious argument. It's an argument of secondary liability. So as well as needing to establish that premise that the AI model is an infringing copy of a training work, they also need to establish a mental element that Stability AI knew or had reason to believe that it was importing an infringing copy. But it's quite an interesting argument because it deals with this point that otherwise, because copyright's territorial, no one country can say that something was or was not an infringement in another country. But if there are sort of secondary grounds of liability that prevent importation, then that could be a way around this. So interesting to see how this argument plays out. Whether it works probably depends on the model in question, how it's been trained and how it works. As Adam mentioned, most of these models aren't supposed to store copies of training work, so they're not meant to, in and of themselves, be infringing copies. They're meant to only learn the relational principles, but this could well vary from model to model.
We've been talking a lot there about the training process, and I guess by definition, when we talk about infringement risk, because of the number of works that have to go into the training data and the learning process itself, that stage in the generative AI process is rightly one where we focus a lot of time from infringement risk. But as Gregor was just alluding to there, in the context of sort of offshoring the training, when you bring the model back onshore, or when you're using it in the UK or using it in the EU, let's talk now about the risks of infringement when these models are generating works, and what. And so again, you mentioned before the need to really get under the skin of how these models work to establish what the risk is. So how can they be designed to reduce the risk of infringing when producing that output?
So in terms of the risks, there is a very real risk that a generative AI model could generate a work that infringes copyright in a work that it was trained on. So I mentioned the Getty case in the UK, where Getty is alleging that Stability AI is infringing copyright in its images. And it's saying that Stable Diffusion sometimes memorizes and generates very similar images to those that were used to train the model. Getty's also saying that the generated outputs infringe its trademark rights because that some of the images generated allegedly feature a sort of warped version of the Getty watermark, which Getty says is trademark infringement. And whether there is infringement or not, whether it's copyright infringement or trademark infringement, really sort of rests on quite a traditional infringement test that applies in the same way, regardless of whether we're dealing with an AI-generated work or not. And an aspect of this that I think is particularly interesting in the UK is that following our Ed Sheeran case, the English court's approach to non-literal copying, that's where the alleged copy isn't exactly the same as the original, but it's just very similar. The court now takes the view that if the allegedly infringing work is so similar that it seems like it would be more of a coincidence and that copying is sort of to be inferred, and if the defendant had access to the claimant's works, then the burden of proof reverses for the defendant to prove independent creation. And this seems like something that's going to come up a lot in the AI context, where if it happens that a generative AI tool produces content that's very highly similar to something that it may have been trained on, and the training work is something that's freely available on the internet, maybe it's well known, maybe there's lots of copies of it, authorized or not, sort of floating around, those two requirements of sufficient kind of objective similarity and access would be fulfilled. And then it might be for the AI company to prove independent creation, which is why things like good record keeping in terms of sort of what works were used for training, or at least where they were sourced from, the kinds of obligations envisaged under the EU AI Act might just be good practice anyway to defend against infringement claims. And another interesting aspect of this infringement analysis is we don't actually know, assuming that an AI tool does generate content that infringes some of the training works, we don't currently know who would actually be liable for that. Is it the user that inputs the prompt that causes the tool to spit out an infringing work, or is it the AI model provider? And the answer to that might depend to some degree on the extent of contribution. So if the user has to try really, really hard and is really, really contriving to make this tool generate something that's infringing, perhaps the user's responsible. If, on the other hand, even in response to a very generic prompt, the tool produces infringing stuff, then maybe the AI provider would be responsible, or maybe it's a mixture of the two. Maybe there's some sort of joint tortfeasorship there. That's something that we still currently don't know. The other thing that we don't know is what would the remedy be? So assuming that an AI model generates an infringing work, and it's proven to be infringing, the rights holder should be able to get an injunction to stop the further use of that work. But the open question is whether they can get an injunction that's of such wide terms that it actually prevents use of the AI model itself. So again, looking at the Getty case, Getty's seeking lots and lots of different remedies, some that relate to the outputs, but some that relate to Stability AI not actually being able to deal with the Stable Diffusion tool anymore in the UK. And one of the sort of parts of the injunction that Getty's seeking is that Stability AI doesn't otherwise infringe its copyright. So if you're an AI provider and you've got an AI model and you've tried pretty hard and you're pretty sure that the model isn't going to generate infringing works, but you can't be 100% sure that it'll never do that in response to a very highly engineered user prompt. An injunction that prevents the AI provider from infringing copyright at all can be quite problematic, because they might not be able to be sure that the tool won't ever generate anything again that infringes the claimant's copyright, and that then maybe puts in question whether they, what it is that they can do with the tool.
Actually, on the EU front, I think it's very important to re-insist on those new provisions that have been enacted by the EU Parliament as part of the AI Act, and which, and actually that was mentioned earlier by Gregor, but providers of foundation models used in generative AI system, as well as producers of such AI system, will have to comply with transparency requirements. Namely, they will have to disclose that content was generated by AI. At the time of design of the model, they have to design the model in such a way so as to ensure adequate safeguard against generation of infringing content. And 3, publishing, they will have to publish detailed summaries of copyrighted data used for training. At this stage, there is no specific guidance that has been produced regarding which safeguards which will be deemed adequate to prevent the model from generating infringement content. For sure, any model which would allow to generate a mere copy of pre-existing work will not pass the test and all the requirements. But we can also suspect that a model which would allow to generate a work which could qualify as a derivative work, such as an adaptation of a pre-existing work, should also be excluded.
Very, very helpful, thank you. So we've now got to the stage in the process where we have generated a work, and as the person or entity that has generated the work, they come then to exploiting it, trying to monetize it, possibly stop other people from using it. Only going to be possible to stop other people from using it if there is some form of intellectual property right that subsists in that output. And talking to a lot of people about this, one of the sort of areas of reticence of over relying on generative AI is possible uncertainty about copyright subsistence and therefore ownership. And that could create all sorts of ongoing problems for someone who would otherwise want to own rights. So I think it's important now that we discuss this really important question of, does copyright subsist in works that have been exclusively generated by AI? And if so, who owns it?
Yeah, indeed, that has been one of the questions that has been discussed from the very beginning of AI being used. And to put it in very, very simple words, although there's no globally unified copyright law, there's still a general requirement with very few exceptions that in order to enjoy copyright protection, the work must be a human creation with some degree of individuality, although the level of individuality may be fairly low. The Berne Convention, which regulates copyright in international area, speaks of the author, which is understood to be a human. European law, although it's not fully harmonized, in most cases also refer to an author or to the expression of the intellectual creation of an author, which must also be human. Thus, results wholly and exclusively, which was your question, Adam, created by AI will generally not enjoy copyright protection. Equally, like so-called downstream creations by users of generative AI tools will not be attributed to the developer of the AI tool. This is the law as it currently stands. And we've all heard of discussions of people who think this situation is not satisfying, that there should be a protection of AI-generated works, and maybe in the form of a sui generis right for either the creator or the developer of the AI. But that is a discussion which is ongoing, and by no means clear where that will lead. At the same time, of course, where generative AI was only used as a tool to create a work that otherwise still has sufficient human individuality, that work, of course, can be protected by copyright. Remember the case law of the European Court of Justice, which has stated that an extract of a text of only 11 words could enjoy copyright protection, speaking about prompts. The question then arises, of course, who owns the right in such a work which was developed with the assistance of AI? Is it the developer of the AI? Would it be the user of the AI, assuming he has used sufficient individuality to create the work? This will clearly ultimately depend on the individual case. However, this has also fairly practical considerations. I think people who want, companies who want their results to be protected, to be able to go against infringers, should not rely wholly on generative AI, but to ensure sufficient human input. Otherwise, they may risk that there's no copyright protection. On the other hand, due to the risk of missing out on protection, creators and developers will be well advised to document the human input in order to be able to show that copyright does exist. Just a few words. Patentability, as regards patents, also usually requires a human inventor. Other IP rights do not necessarily require a human. For example, a trademark, which is designed distinctive, can be perfectly created by AI and then be protected. Also, other neighboring rights under copyright, for example, database rights or sound carriers, could also be protected under copyright, even if created by AI.
Yeah, just to add something, something that is interesting, we can see how the U.S. Copyright Office canceled in February the intellectual property registration of the comic, of one comic, it was called Thyra of the Down, that was created by using Midjourney, a generative AI system. So what is interesting is to see how the U.S. Copyright Office asserts that the prompt, because the prompt was the users were giving prompts to the AI system. So the prompts only can influence the generator of the image, but the instruction text does not dictate the specific result. And this result is unpredictable when we use an AI system. So at the end of the day, the user have not control over the final image generated by the AI. And this brings also another question regarding liability. And we can see how a European Union is also modifying defective products law regarding we have more players that can involve in the liability of a product or an infringement of law. We had from until now we had the importer, the manufacturer, the distributor, but now we have the operator. So maybe the operator has something to say or that involves the liability. That's something that is really interesting.
In the UK, we have a slightly different approach. At the moment, there's no indication that AI-generated works can't be protected by copyright simply because they're AI-generated. They would need to meet the threshold of originality in order for copyright to subsist, but that's a pretty low bar. The UK Copyright Designs and Patents Act actually expressly contemplates that computer-generated works can be protected by copyright and has provisions around the term of protection and ownership of those works, again, assuming that they're original. And these works are owned by the author, as is the case with other works, but here the author is considered to be the person who made the necessary arrangements for the creation of the work. And again, it's not entirely clear whether that would be the AI service provider or the user that inputs the prompt, or both, or whether it depends on who made what contributions to the end work. On that note, it is possible that copyright could also subsist in the user's prompts if they constitute original creative expression. So in, for example, the Shazam and Only Fools, the dining experience case last year, the Intellectual Property Enterprise Court found that there could be copyright in characters as works in themselves. And there might be instances where a user's inputting prompts where they're creating characters or other narrative elements that are of sufficient detail and creative expression that they own the copyright in the prompt, sufficient to be able to restrain the use of the generated work, whoever owns that generated work.
Thanks, Yang. So we've heard then, wrapping up almost, that we've got possible risks of infringement in the training process. We've got possible risks of infringement in the output process, and we've got the kind of possibly more kind of commercial risk that the output won't be, in some jurisdictions at least, protectable by copyright at all. So if you're a business looking to use a generative AI system, what diligence questions should you be asking of yourself, whether that's sort of internally or of the providers of these systems?
Yeah, just very quickly, I will say that two things are very important to have in mind. First, the company needs an AI usage policy in order to mitigate all the risks that you mentioned, Adam. That we are here, we talk about intellectual property, but there are other risks that have to be mitigated, and we can talk about confidentiality information, trade secrets, cybersecurity, or data protection. So all these risks can be mitigated if you have implemented and developed an AI usage policy where you are going to inform and to train your employees how they have to use this AI system. That is very interesting and important. If we remember, there was a case in Samsung. Samsung banned the use of AI system in their own company because they have a breach of confidentiality, because the engineers include in a prompt in the AI system a code source in order for the system to help them to fix the bugs of the code. And the code was something that was trade secret and confidentiality. And then when they used this code in the AI system, the code was everybody had the codes. It was something that a disclose of the confidentiality of the company. So it's very important to know which are the uses that are permitted in the company and not tolerated in the company. And the training of the employees is something that will mitigate this kind of risk.
Another practical aspect, this is probably quite an obvious point, but any organization looking to use a third-party AI tool should review the T's and C's very carefully. Some of the areas of uncertainty we've talked about in terms of who owns the prompts or who can use them, or who owns the outputs, or who can use them for what purposes, may well be answered in the AI service providers' T's and C's. And the other sort of practical point is, depending on the risk profile of the use case, it might actually be prudent to do a bit of deeper due diligence into the tool, into how it was trained, what it was trained on, and exactly how it operates, if it's a tool that you're using to sort of create really material creative or software assets, for example.
Greg or Marco, any last observations from you guys before we call it a day?
I think I would underline what Christina and Juan said. Clearly, training employees is core important, and educating them what results, what consequences it would have to use AI is very important. Also, of course, looking at license agreements, how far, when you license out content, do you exclude TDM, machine learning, things like that, or do you want it when you license in content? Also looking at older license agreements, whether they would include text and data mining, machine learning will be diligence questions for companies.
Thanks, Gregor. Well, thank you all for your amazing contributions there, and thank you to our audience for staying with us as we explore all of the different elements of generative AI and their implications on intellectual property. A plug now for our next sessions, which you'll see on screen coming up in August and September, dealing with the liability for the AI itself, and on the GDPR implications in September. So keep an eye out for your emails on how to register for them. And yes, thanks again for everyone for joining us. And you have our details, so we'd love to hear from you with any follow-up questions you'd like to pick up. So farewell from us, whether it's good evening or good afternoon, wherever you may be, and we look forward to being in touch soon.